Welcome to Second Take, the show that focuses on the issues behind the news. The dispute around the iron ore rights looks set to continue for some months yet, but there have also been some developments. Terence Creamer joins me to discuss the latest. Terence, welcome to Second Take. There have been some revelations in the media about Imperial Crown Trading's application. Can you take us through those?
Yes, the court case involving Kumba against the Department of Mineral Resources as well as Imperial Crown Trading is sort of coming up later this year, probably around August. So things are coming out in the media as well as through affidavits. And our colleagues in the media have been quite busy and have been giving us some added detail as to what could come up in that court case. The one thing that Webb has revealed is that the geologist that was involved, that RCT said was involved in helping them prepare the Sishen application, has turned around and said, no, look, I was never really involved in that process. He acknowledges that he did sign a document that was submitted to the DMR, but he feels he signed that under false pretenses. So I assume Kumba will probably use that in some ways, in the sense that they've been saying that the application of RCT was in some ways fraudulent. And in Business Day, we've also seen that this unknown personal link between RCT directors or RCT individuals and the Kimberley office of the DMR, they have uncovered that there are some personal relations at that office. Whether it's a smoking gun, and it shows that how RCT got access to or insight into the fact that these rights that were previously held by ArcelorMittal South Africa were expiring, and insight into Kumba's application process, which Kumba claims was badly photostated and attached to RCT's application. You know, whether this is sufficient personal linkage is a matter for the court to decide. But I think it's another area that Kumba will probably highlight in this case. So there have been developments, and another development is that ArcelorMittal South Africa is looking to join the case, and that joining application has to be heard ahead of the court case or the matter actually coming before the courts, and that will probably take place this month. And then we should start getting into the actual meat of the heart of the matter sometime later this year.
In the meantime, ArcelorMittal South Africa is moving ahead with what it terms an iron ore self-sufficiency program. What is the company doing?
Well, we heard this week that ArcelorMittal has got a near Sishen prospecting acquisition on the cards. They didn't reveal the name of the property or the company that currently holds it. All they said is that they have deployed a team to drill, and over the next 6 months there will be drilling activity. And they're hoping that is going to lead to a firming up of this resource in the Northern Cape, which is the iron ore rich area where Sishen is based and other mines are based. And they would like at some point, probably over the next 3 to 5 years, to develop a mine capable of producing between 2 and 3 million tonnes a year. So you can see that they're looking to really try cover their bases. They made this fatal mistake of allowing this mineral right to lapse. They are in this arbitration process with Kumba, which we now hear will only really be heard in 2012, mid-2012 or early 2012. And there they're really trying to safeguard the supply agreement with Kumba. So even if the rights lapse, they're trying to delink the rights from the supply agreement and saying they should continue to get cost plus 3%. And in the meantime, they've also got an interim agreement with Kumba after Kumba Sishen Iron Ore Company, in fact, terminated the supply agreement early last year. An interim agreement was put in place to buy us over. That was supposed to expire on July 31. They're in talks with Kumba to try and extend that for the duration of the arbitration process. Whether we'll see the same terms or whether new terms will be implemented, that is also not known yet, but we should know that within weeks. And then the other base that they were trying to cover was if they couldn't own the mineral rights through the arbitration process and through what the DMR has done in allocating it to RCT, the prospecting rights to RCT, they were then seeking to include RCT in a black empowerment agreement. And that process has been on and off and on off. In fact, it's never really been put to shareholders. The minority shareholders, many of those minority shareholders have raised doubts about the whole black empowerment partner. But that there's conditions precedent that there's a due diligence that's been underway for many months. And they said, and that's also looking quite vulnerable, I think, that whole deal. That was to secure a partner, but also to secure, it was in a linked, although two separate transactions that was linked in the sense that they would also buy ICT in the process and therefore get access to potentially decision rights. So it's quite complicated, as you can see, and that process should also sort of come to a head in the next couple of weeks, not months, is what ArcelorMittal is saying.
Terence, when in your view will we begin to see a resolution to this issue?
Well, I think that's still hard to say. I think we're still at the early stages of this. We have arbitrators now. We know when the arbitration date will be set. We have a court process that has to unwind, and we know that some of those building blocks to that court process are starting to be put in place, and those legal hearings should take place starting towards the end of this year. But these processes, take very long. So I don't know if we're going to get resolution this year. I think 2012 is probably the year that we'll have much more visibility.
Thank you very much. That is the Second Take show for this week. Thank you for watching, and join us again next time for more news analysis.